Yega Bombomti Chini Tanchu Mungong.
You know, I really love these versus videos. The stark comparison of situation to situation is just eye opening. It's not a good thing. It's really not a good thing, but it's just eye opening. And I'm so nosy that I just can't help myself. I saw this trial a while ago. And when I seen his trial, I said, oh, hell no. Oh, hell no. You can't tell me this is the same world we live in. I do not know the state of this situation. I don't even know if they say it. I watch Judge Boyd a lot, but I still don't know. I don't pay attention to that shit. But listen, this lady whooped, and I mean she whooped this judge's ass a little bit, just a little bit, right? While her boyfriend and a friend was whooping on the husband of the judge. Okay? The judge had substantial, as you will see, the prosecution will lay this out nicely, so I'm not going to talk much. The second judge was dazed and confused a little bit. She might have got spit on, allegedly. I don't know if he spit on her or if he spit on somebody else. She was not toe up. She was not toe up. She might have had her hair pulled. She was dragged down to the floor. She pushed up against the wall. It was a little jumble. It was a little tussle. I'm not taking. Baby went to work the next day. She went right on back to work the next day. And then she met with the same man later in the week, maybe. I don't know. In close proximity to the incident and handled business. She sentenced him. I think 19 to 48 months. Whatever the fuck that means. I don't understand. Is it a range and he just got to get to the 19 and then they decide? Well, now it don't matter. He going to be in the jail for the rest of his life. Allegedly, in my opinion. But this lady, did she ever go to jail was my question. I believe she must have gone to jail. If they went and found a judge bloody or anybody bloody, they're going to take you to jail. I believe. I want to know how long she was in there and how it was that she got out. That's what I want to know. Yep. So we're going to watch this. We're going to compare. We're going to contrast. We're going to do our versus thing to do basic, to be bougie way. It's going to be real bootleg. And we're going to hope it makes sense. I just want you to pay attention, and I want you to let me know if it seemed like, one was more severe, and that's why one was more severe. I hope y'all enjoy.
Understanding the complainant in this case is Rebecca Martinez.
Yes.
All right, and is that the Rebecca Martinez who's on the fourth court?
Yes, Judge. Yes, sir.
All right.
President of the courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that it was fair and right in this case. So no objection.
One from Associated Press and one from Fox 5. Does the state have any opposition to these media requests?
Your Honor, I'll submit it to the
Does the defense?
I'll submit it to the court.
Okay, I'm going to sign and approve these media requests. They are not for live streaming, and they are only for any sort of media that the media requested. All right, as for disclosures, Judicial Canon 2.11, comment 5, that I do know Judge Mary Kay Holthus. I know her very casually and only professionally. I've never socialized with her outside, say, a professional event. I do, for instance, not know her phone number. I don't think she knows mine. We're not connected on social media. I've never worked at the district attorney's office, where I believe she worked for her entire career. Therefore, I say I see no reason to recuse. However, I make those disclosures under Rule 2.11, comment 5. Mr. Redden, have you been given?
All right. So are there any witnesses that anyone wishes to present, state?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant, which the court has already noted that they read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter. I will be speaking and Ms. Segundo may say a couple of words, and Ms. Segundo's parents are present in support of her today. I can stand with Mr. is standing here in support of her today.
All right, thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Gracie Segundo.
All right, and with regards to County Court Cause number 6933701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just
Uh,
nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
I will go ahead and proceed with a guilty plea, Your Honor.
All right, so the county court cause number 6933701, how do you plead to that? All right, and state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number?
Mr. Redden, have you been given a copy of the criminal complaint this morning?
Yes, I have been given one.
You're being charged with count 1, attempt murder, victim 60 years of age or older, a felony. Count 2, battery on a protected person resulting in substantial bodily harm, victim 60 years of age or older, a felony. Count 3, extortion by threat, a felony. Count 4, intimidating a public officer, a felony. Count 5, 6, 7, 8, and 9 are all battery on an officer, the same name victim. Oh, and by the way, I do not know any of the other victims named in the criminal complaint. Those are all felony offenses. Count 10, performance of act or neglect of duty and willful or wanton disregard of safety or persons of property resulting in substantial bodily harm or death, a felony. Battery on a protected person, count 11, that's a gross misdemeanor offense. Count 12, battery by a prisoner, a felony. Count 13, unlawful act related to human excrement or bodily fluid, a felony. All allegedly occurring on January 3rd of 2024.
All right, so the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. It was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that date forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals, and in her work and her career in taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issue.
Do you understand these charges?
Yes, I understand.
Can you afford to hire a private lawyer at this time?
Wait.
I'm sorry?
I'm trying to,
Can you afford to hire a private lawyer of your own expense and choosing?
no, not at this time, no.
Are you a veteran or a member of our military?
No.
I can appoint a lawyer from the public defender's office to represent you.
She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of. It was just something in a reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. I have nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
No, there's-
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I couldn't show you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity. People need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have.
Thank you, Your Honor. And prior to Your Honor calling the case, I did, as a friend of the court, talk to Mr. Redden about his right to a Valdez Jimenez hearing. I know that he did not have one in initial appearance court. However, he's going to be choosing to waive the prompt hearing given the circumstances that happened yesterday in district court where he's already been sentenced in his other case.
Okay, so he was sentenced?
Correct.
Okay, was he sentenced to jail or prison?
Correct.
Okay.
19 and 48.
There. I don't understand how an elevator is at capacity. People need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight and then you decided to get involved in that fight.
I went to go and try and pull my friend away and then I don't know, it was just a bunch of people and somebody hit me and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. In addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here.
So he understood that and said that he's not trying to have the hearing today.
Okay, that's fine, and I'll canvass them on that. My only issue is I think what has happened is some standard bail figures have carried over since booking. So by the time he sees a judge, he is entitled to a Valdez Jimenez hearing, but it is at that point that the court sets release conditions. So I'm removing the standard bail numbers that were only assessed at at booking, frankly, until he sees the judge. And given the attempt murder charge of count 1, that is a set in court bail. So the standard bail numbers will be removed. It will be replaced with a set in court bail or release condition. He is entitled to a Valdez Jimenez hearing within 48 hours unless good cause shown. But you say, Mr. Redden, Ms. Medina tells me that without waiving a bail hearing completely, you're at least willing to waive it for now because you have some other issues you have to handle. Do you understand and agree with this?
Yes, and 1948.
Okay.
So my question was, how much were you able to perceive about what was going on around you during the middle of that physical altercation?
And I was not able to see when I was in the ground what was taking place after that.
Okay, and we can agree that the incident in question, the basis of this criminal case here today, is something that happened during the middle of your physical altercation, right?
While I was on the ground, yes, and then afterward, I did get up and partially saw my wife on the ground with a bloody nose. She was in a daze, and I asked her what happened, and I told her that she got hit. She said, "Yeah, I got hit multiple times." And I said, "Well, why didn't you defend yourself?" She says, "I couldn't because I was being held down."
Can you say for certainty whether or not Mrs. Segundo was acting in defense of another whenever she got involved in this incident?
I'm gonna object to relevance.
All right, that'll be overruled. You can answer the question if you know.
I can't say that, but you know, I can answer.
Oh, and I understand, Mr. Martinez, the want for justice on behalf of the injuries for your wife. I just want to make sure that we're also serving justice here for Mrs. Segundo today based on her amount of involvement in this incident.
All right, so he'll just be on a set in court bail unless further ordered by the court. We need to set his preliminary hearing. Would you like that set within 15 days?
He's going to also waive the 15-day set and we'll do 30 days.
Okay. Sir, you have a right to a preliminary hearing within 15 days, and Ms. Medina has said that she's talked with you about that, and you're willing to give up that 15-day period and instead set your preliminary hearing within about 30 days. Is that okay?
Yes, that's fine.
Is this okay with the state?
Yes, Your Honor.
All right, Ms. Segundo, I've listened to all arguments. I want you to know I paid very close attention to the arguments that were presented, to the witnesses, and to all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life, right? It doesn't mean that the person is a horrible person. And I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that. But we can't turn back the hands of time, right? And the problem in this case, and one of the things that I'm looking at is the fact that the complainant has serious injuries. And it has nothing, my consideration on whether they're a judge or not, that's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example. Then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. And I've read the report that was given to me about her injuries, and I've read the PSI report, and I've read the police reports again in this case, because I always like to review things. So I understand that you're very sorry for what happened, but sometimes, yeah, it's great that you're sorry. It's great that you've internalized things, but there is still some punishment associated with it. And I understand that sometimes when people have felony convictions, they say, well, now I can't do this, I can't do that, I can't do this. But then when you look at the complainant has some lifelong issues. And that's the report that I was given and that your attorney has read. The injuries that she suffered are not going away. And from the report I read, it sounds like they're never going away. She's always going to have those injuries. I understand, as I said, that you're sympathetic, and I believe that you're sympathetic, and if you could do things over, you would. But I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's a transfer to Houston, Texas, Harris County. Taking consideration County Court Cause number 693701. There's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours of community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Riojas. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
The state won't object, Judge.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yeah.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. So what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, pick another day to argue about it. You understand? All right, good luck to you.
Thank you.
Okay, does it stay? Yes?
After we get the date, can we approach?
Sure. Is there anything else, Ms. Mercer, you want to address?
No, Your Honor.
Okay. All right, here's a 30-day preliminary hearing date unless I see you earlier, and if you'd like to approach, you may.
February 14th at 9 a.m.
Completely different scene inside of that courtroom.
I mean, I'm gonna say maybe it's because it was more than one person. I forgot it involved like the bailiffs and of course our brave court hand, whoever he was. So maybe it was because it was multiple people and that was the biggest difference. But I'm still a little bit confused, just a little bit. If you can explain it, just let me know in the comments. I'll see y'all next time. Bye.